into the case.
I would assume they were the same people because it was minutes later that same area, same people.
But that's your assumption, correct?
Yes.
You don't have any basis for that based on your observations?
No.
So you hear a voice or voices outside the window that catches your attention, and you don't notice at that point that there's any particular confrontation or any kind of distress in the voices?
No, just someone talking initially very loud.
And it could even have been one person, correct?
If they were talking to themselves, yes.
Or on the phone.
True. But so loud, I can't imagine someone talking that loud.
But you didn't make out any words.
No.
You just heard sound.
Yes.
So if someone's talking over the wind on a cell phone.
We have to take a break. Newsroom continues after this.
Spoke loudly, that could have been that.
Everything is ruined.
It's okay. We're ready. When the things that matter most are on the line, make sure we are too. The Fire and Water Cleanup Team at 1-800-SERVE-PRO. Like it never even happened.
Hey, it's Michelle Bernstein, here to take your lettuce from drab to fat with new lean cuisine salad editions. Just BYOL. First, fry your dressing. Next, steam your grilled chicken and veggies. Then dress it, add your crunchy toppings, and voila! Enjoy.
If I can talk to anyone as much as I want to here, namaste. Uf, más soledad. And why am I limited when I make international calls? Exactamente, amiga. That's why we connect the world with one low rate for unlimited calls.
So I can call China as much as I want?
Do that. And India? And they can call my girlfriend in Brazil.
Claro, over 60 countries. People thought we were crazy to give you unlimited long distance.
Way too generous.
Feel free to talk at Vonage.com.
This is CNN Breaking News.
I'm Wolf Blitzer in Washington with our breaking news coverage. This is the final day for the United States Supreme Court to issue opinions this term. We're expecting rulings literally at any moment now on two landmark cases on the future of same-sex marriage in the United States. Both will test whether gay and lesbian couples have a constitutional right to get married. Jake Tapper is over at the U.S. Supreme Court with our legal analyst. He will bring us the rulings, and our correspondents will bring us reaction. Don Lemon, Dan Simon, Dana Bash, and Brian Todd, they are all standing by. And our chief national correspondent, John King, our chief political analyst, Gloria Borger, they're here in our Washington studios. Let's go to Brian Todd, though, first. He's outside the United States Supreme Court. Brian, a lot of folks are anxiously awaiting the decisions on these two critically important cases.
That's right, well, very anxiously awaiting it. A couple of people around me have said they're very nervous because the moment is at hand. The decision coming down in just minutes. I've got one same-sex couple with me here, Molly Wagner and Sharon Burke. They're students at American University. They have braved the swamp-like heat of Washington, D.C. to be here. Molly, why?
You know, they said the decision is coming down today, and we just felt that it was really important that we get here and show this is something really important to us and that we're here, we're not going away, and this decision impacts us directly.
And what about you, Sharon?
I mean, I'm just hoping the court's on the right side of history this time. So, I mean, I just wanted to come down here and let everyone know that we're not going anywhere.
A little nervous? Moments away here?
Nervous, cautiously optimistic, you know.
All right, guys, thank you. Anyway, now we've got...
Hey, Brian, hold on for a moment, yes. Brian, because I just want to alert our viewers, the justices have now announced that a critically important case, the Defense of Marriage Act, whether it is constitutional or not constitutional, has been reached. This is the United States versus Windsor. John King is over at the Magic Wall for us. John, explain what this case is all about, the Defense of Marriage Act, or Doma, as it's called.
Let's take a look. The case is called United States versus Windsor. This is not a question of whether or not same-sex marriage is legal. It is a question about the practical effects of if a state does recognize a same-sex relationship, what happens when you apply for some federal benefits? Because the federal government does not right now. The Defense of Marriage Act defines marriages between a man and a woman. So at issue in this case is whether Doma, the Defense of Marriage Act, violates equal protection guarantees. Let's look at the argument. The government says, since the federal government does not recognize same-sex marriages, that you can't claim, say, the married rate for estate taxes. You can't get Social Security benefits for a surviving spouse. Any federal benefits that might be available in a male-woman marriage, not available to a same-sex relationship. That is the argument. The respondent in this case is Edith Windsor, who's had a same-sex spouse, who passed away, and she wanted to get the benefit of the estate tax you would get if you are married. The federal government said we can't do that because the federal government does not recognize same-sex marriage. So this, Wolf, is not a question of whether the court is going to embrace or deny the right, a federal right to same-sex marriage. It's more about the practical effects of that question when you apply for legal benefits. And if you go through this as we play it through, I mean, there's a bigger question. I'll bring this up as we await the other decision as well. Here's the issue. You have any red state or orange state, you either have recognition of same-sex marriage or at least broad recognition of civil unions and the rights of same-sex couples. What happens? The Defense of Marriage Act decision that we're waiting to get the details on, what happens to folks who have those relationships in these states where they're recognized by the state, either fully or mostly, their spouse passes away, then what happens?
Good point. All right, John, hold on for a moment. Gloria, you spent a lot of time speaking to some of the attorneys involved in these gay marriage cases, two critically important ones. The Defense of Marriage Act, we just heard John explain some of the background. It's interesting that on this particular case, it's a federal law, the Defense of Marriage Act, which defines marriage as being only between a man and a woman. The Obama administration refused to defend the federal law.
Right, exactly, on Proposition 8 and on Doma. I think that what we've seen over the years since these cases have been litigated is a real shift in public opinion on the question of same-sex marriage. And let's take a look at this. We have asked this question back to 2003 about whether you think marriages between gay and lesbian couples should be recognized as valid. And if you go back to 2003, you see that 31% of the American public said, you know what? We don't think it should be recognized, and now 55%. So in one decade, support for same-sex marriage has almost doubled in this country. And so the question today we have before the court is the court effectively going to follow public opinion on this, Wolf, which has really shifted dramatically.
And then we do know that a decision has been reached. We're going through the writings of the justices. We want to be precise, obviously, and make sure we fully understand what these justices have decided. But at issue in this first case, the Defense of Marriage Act, Gloria, is the specific question is whether or not it's constitutional to prevent federal benefits going to couples who are of the same sex.
And if you are legally married in a state, the question is whether the federal government should recognize your benefits. That's the key question here for the Defense of Marriage Act.
And we should know momentarily what these justices have decided. Tom Foreman is taking a much closer look at this Defense of Marriage Act as well. Tom?
Yeah, hey, Wolf, right now, about 300 people are inside the chambers there. We can't take you there with any live cameras, but we can virtually set the scene. They're listening to what the justices are saying about this. Just as last March, they listened to the justices discuss this. Justice Roberts had a concern back then about the very thing John King mentioned a minute ago about the Obama administration. He pointed out the Obama administration would not defend it in court because they said it was unconstitutional, and yet they enforced it as a law. He said of the president, I don't see why he doesn't have the courage of his convictions. Justice Kagan was concerned about how it was enacted, that this was moralizing, not lawmaking by Congress. She said Congress decided to reflect collective moral judgment and disapproval of homosexuality. Justice Kennedy considered a very key vote in all of this, and a key part of the thing said basically he wanted to know if this was even something that Congress should be involved in. The question is whether or not the federal government has the authority to regulate marriage at all. And Justice Ginsburg jumped in on that issue you were discussing a while ago about how some states have approved it. But then she said the federal government comes in to say no joint tax return, no marital deduction, no Social Security benefits. One might well ask, what kind of marriage is this? That's what the justices were saying back in the spring, Wolf. Now we're going to see what decision the summer has brought.
Tom Foreman, thanks very much. Obviously, a lot at stake right now in this first case, whether or not the Defense of Marriage Act, which President Bill Clinton actually signed into law back in the 90s, is or is not constitutional. There's a lot at stake, of course, for everyone, including the President of the United States. Jessica Yell is traveling with the President. Actually, let's go to Jessica in a moment, but Jake Tapper is over at the U.S. Supreme Court. Jake, I understand you've gone through the paperwork now, and you're ready to tell our viewers what the justices have decided.
That's right, Wolf. This is a landmark ruling about whether or not the federal government's refusal to recognize same-sex marriages, people who have been married legally according to the laws of their state, whether the federal government's refusal to recognize them is constitutional or not. I'm going to bring in Jeff Toobin, who has been going over the decision. Jeff, it seems like the court has said the federal government does not have a right to not recognize these marriages.
Doma is gone. This is a major, broadly written opinion which strikes down the law on the ground that it discriminates against gay people. This isn't a decision about states' rights. This isn't a narrowly written decision. This is a decision that says the federal government, by passing Doma, demeans those persons who are in a lawful same-sex marriage. That's a quote from the opinion. This opinion says that the federal government cannot discriminate against people who have valid same-sex marriages. They are entitled to file joint federal tax returns. They are entitled to Social Security survivors benefits. They are entitled to be informed when their spouses are killed in action. This is a decision that says gay people have equal rights under the federal Constitution when it comes to this statute.
And Jonathan Turley, I want to bring you in because Jess is making the point here that this was not a decision made on states' rights grounds. This is not the court saying we leave this up to the states. This is the court saying under the Equal Protection Clause in the Constitution, the federal government cannot do this. That could be significant when it comes to this other ruling that we are expecting on California's ban on same-sex marriage.
You know, it's a fascinating, even a breathtaking decision because Kennedy went way beyond where he had to go. And this has always been viewed as an incrementalist court, a court that wants to not get ahead of its skis on issues of social division.
We've seen that this week with other decisions that have been splitting the baby, as it were.
That's exactly right. And here, Kennedy goes out of his way to say, we're not doing this on states' ground. This is about equal protection. It's about the dignity of marriage. And this is about marriage. It doesn't matter whether it's between a man and a woman or two men or two women. And in that sense, it's the other shoe dropping after Lawrence, because this was the question left dangling in Lawrence when the Supreme Court said you can't criminalize homosexual relationships. But the court really doggedly avoided the marriage question. Kennedy is just bursting on the scene here and saying, you know what? It's marriage, and it's all marriage. And you can't deny it to these couples.
And this was 17 years ago that President Bill Clinton, signed the Defense of Marriage law into law, saying that the federal government will not recognize same-sex marriages, no matter what the states do. Jeff, as soon as you saw who had written the opinion, Kennedy, and who he was joined by, the four, for want of a better term, liberal justices on the court, you knew what the decision was.
Well, but the thing that's so many extraordinary things about this decision, we now know what the first line of Anthony Kennedy's obituary, many years in the future, will be. He is the justice who is the author of the three most important gay rights decisions in the history of the Supreme Court. He wrote Lawrence v. Texas, which said in 2003 that gay people couldn't be thrown in prison for having consensual sex. He wrote the Romer decision, which struck down a Colorado law that discriminated against gay people. And here, he has now written the opinion that says the federal government cannot put validly married gay people into a separate and lesser category of rights holders.
I want to go to Brian Todd, who's on outside the Supreme Court right now, where there are many same-sex couples and straight couples and straight individuals celebrating this decision. Brian, who is with you right now?
Jake, they are certainly celebrating. I talked to these two ladies just before the ruling. Now I'm going to talk to them after, because they were a little nervous before the ruling, but now they're just happy. This is Molly Wagner and Sharon Burke. Molly, first your reaction.
I don't even have words. I'm just so happy and just overrun with emotion. I couldn't be more proud of my country and of the Supreme Court today. And I'm so happy to be here and be part of it.
Sharon, how about you?
We'll wait for Prop 8 and then, but, I mean, this is a major victory for everyone in the community.
All right, Sharon, Molly, congratulations. A little bit of chanting here, Jake, as they're waiting in anticipation of the Prop 8 ruling. And I'll throw it back to you.
All right, thank you so much. Just to reiterate for those just joining us, there has been a 5-4 decision in the Supreme Court striking down the part of the Defense of Marriage Act, which says the federal government does not have to recognize same-sex couples. That is no longer the law of the land. Justice Kennedy, writing the majority decision, the majority opinion, said that that is a violation of the Equal Protection Clause of the Constitution. Jeff Toobin, this is going to have a lot of specific ramifications for individuals. This case was brought by a woman who had to pay $363,000 in taxes because even though she was married according to the laws of Canada, where she and her same-sex partner were married, the federal government did not recognize that, and therefore she had to pay $363,000 in taxes. This is going to mean real things to real people.
Real things to real people, to thousands of couples. With the same-sex marriage is legal in 12 states in the District of Columbia. A lot of people have been married. A lot of them, all of them, have been denied the privileges of marriage under federal law. Now they will have it. That means joint tax returns. That means Social Security survivor benefits. It means that there are hundreds of references to marriage in federal law. These gay people are now married under federal law. That's a dramatic, dramatic change in their status. It's an improvement in their status. We are, of course, still waiting for the decision in the Proposition 8 case. I think it is, I don't want to draw any conclusions about what they might do in Proposition 8 based on this decision, but it certainly makes that decision quite interesting.
It suggests, and we don't know what the court will rule in the Proposition 8 ban on same-sex marriage in California, but the suggestion that Kennedy says that this is a violation of the Equal Protection Clause of the Constitution suggests that that's something that he won't be able to ignore for the next rule.
Let me just read one sentence here, which I think tells you a little bit about the tone of the opinion. Doma instructs all federal officials, indeed all persons with whom same-sex couples interact, including their own children, that their marriage is less worthy than the marriage of others, unquote. The federal statute is invalid, for no legitimate purpose overcomes the purpose and effect to disparage in and to injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. That's a pretty broad statement that gay people have equal rights to straight people.
And just to get into the specifics of what this might mean, there are 12 states plus the District of Columbia that currently recognize same-sex marriage or are about to, because Minnesota and Rhode Island, they passed same-sex marriage that will happen in August. What does this mean in the 36 states where same-sex marriage has been banned or is not allowed? What does this ruling mean, Jonathan Thurlow?
Well, we're waiting for that second opinion to determine whether there still remains a prominent state law issue here. The court could have rendered this decision on equal protections grounds, but still, in the second opinion, recognize the right of states to make this decision. And that's why this is the important linchpin. The language of this opinion is broad, and it would seem to indicate that there are equal protection rights that extend beyond the narrower question of federal benefits. But remember, right now, what this means is that if you can get through a state that recognizes your marriage, the federal government will recognize it as well. But you still must be married in a state that recognizes a union between two men and two women.
And that's a minority. That's only 12 states and the District of Columbia now.
That's right. And so the question is there still this live torpedo in the water of a state law issue? Is Kennedy, who's a big believer in federalism, going to support the right of the court and say, we're going to leave this up to the states? We've answered what the federal government can't do, but we have not said what the states can or cannot do.
I want to go to Brian Todd right now. We keep hearing all these cheers behind us. We're only a block away from the Supreme Court. We keep hearing all these cheers from activists who are very excited about this decision ruling that the federal government no longer has the right to discriminate against same-sex marriages. They have to acknowledge them and accept them and bestow upon them federal benefits if the couple was married in a state where same-sex marriage is legal. Brian Todd, tell us who you're with right now.
This is Phil Addy. This is Catholics for Equality. Is that the name of your group, I take it?
Well, actually, I'm the former executive director. We disbanded the organization last year.
All right, well, what's your reaction to the striking down of this key provision of the Defense of Marriage Act, denying benefit?
This is a historic day. not just for LGBT people, not just for Catholics, but for every American and every person across the globe. This will have a ripple effect in countries that we don't even realize have LGBT concerns.
We're just moments away from the Proposition 8 ruling. We could hear it at any minute now. What is your sincerest hope for that?
Well, either that they will rule it unconstitutional, or at the very least they will honor the lower court ruling and decide not to hear the case, which I think is more probable, but we'll see.
All right, Phil, thank you very much for joining us. A real sense of jubilation here, Jake, after the first ruling. Second ruling maybe minutes or seconds away, and the crowd is a little less charged right now because they're a little more nervous. So we'll throw it back to you.
All right, and as we go over the Proposition 8 decision, we're going to throw back to Wolf Blitzer in the CNN Washington, D.C. Bureau to chew over this huge, momentous decision, basically saying that the Defense of Marriage Act passed in 1996, signed by President Clinton, is no longer the law of the land. Wolf?
Jake, we'll get back to you as soon as we know what the decision is on the Proposition 8 ban on same-sex marriage in California. That should be coming up momentarily. But right now I want to go to Senegal, Dakar, Senegal. The President of the United States is on his way there. Our chief White House correspondent, Jessica Yellen, is already on the ground. Jessica, this is a major win for the president who opposed that Defense of Marriage Act and refused to allow federal lawyers to get to support this federal law before the justices of the Supreme Court.
That's right, Wolf, and the president considers gay civil rights a legacy issue and one of his greatest domestic achievements. So the further advancement of gay civil rights will no doubt be cheering for him. I'm told that they were planning to watch coverage of the decision on Air Force One because the president took off from Washington, D.C. before the court issued its decision. So the president learning this as he is headed here to Senegal, some irony in the fact that he will be making his first remarks about this decision here in Senegal, a country in which homosexuality is illegal. But President Obama also now has some kind of complications of his own, potentially. Now that Doma is struck down, there is this question of the states that do not recognize same-sex marriage, and his administration has been preparing how will his agencies deal with the hundreds of federal benefits that go to same-sex couples in all these states that don't recognize same-sex marriage. That'll be a question for the next days as his lawyers read through this decision and see if the court gave his administration any guidance, or if that will be entirely up to the president and his team.
A 5-4 decision by these 9 justices of the United States Supreme Court rejecting the Defense of Marriage Act. The 5 in the majority: Stephen Breyer, Ruth Bader Ginsburg, Sonia Sotomayor, Elena Kagan, and the key deciding Justice Anthony Kennedy. The 4 dissenters: Antonin Scalia, Samuel Alito, Clarence Thomas, and the Chief Justice John Roberts. Let's get some reaction. Eric Schneiderman is joining us now. He's the New York State Attorney General. Also joining us, Carrie Severino, the Chief Counsel and Policy Director of the Judicial Crisis Network. Attorney General Schneiderman, what's your reaction?
Great decision, completely consistent with lots of Supreme Court rulings holding that marriage is a fundamental right. It's good that they went this far. I think it makes it, look, for Edith Windsor, who was a New Yorker, who was married with her partner for over 40 years and has fought this through. Congratulations to her. This is about equality, and this means the marriages of people in my state, in New York, and all over America between same-sex couples are going to be treated equally under more than 1,100 provisions of federal law that use the term marriage or define benefits according to marriage. It's a great win, not just for the gay community or for Edith. It's a great win for the American tradition of equal justice under law. And I must say, I did not count on them moving this far. I think it makes it very difficult for them to reverse field on such a fundamental ruling about equality under the Fifth Amendment in the Prop 8 case. I look with interest, but for New Yorkers, for all the states that have legalized marriage, for all of our couples and everyone in America, this is an incredible victory.
All right, let's get some reaction from Carrie Severino right now. Carrie, before we get your reaction, what this does do is that same-sex couples who are legally married in the United States, they will now be able to have to file jointly on their tax returns. Their marital deduction on tax returns will be applied. They will get Social Security survivor benefits, official notification of next of kin if their military spouse is killed in the line of duty. and spousal deduction for federal estate tax. That was the issue in this specific case, United States versus Windsor. Edith Windsor will now get $300,000 back from the U.S. government because that's the extra tax she had to pay when her partner passed away. What's your reaction, Carrie, to what the 5-4 decision means?
Well, this is a disappointment for those who are worried about judicial supremacy, which is what Justice Scalia talked about in his opinion. This is the court reaching out to decide a decision that really wasn't before it, even on standing grounds and procedural grounds, let alone reading into the Constitution a right that isn't there. But I think the silver lining is that we see, as the Chief Justice pointed out, that actually this is a somewhat narrow decision in terms of leaving it to the states, really. It's amazing that 30 years ago you would never have seen this kind of decision based on the basis of the states having the sovereignty here. And I think that is a fundamental American principle that we can all get behind. This is something that should be decided at a lower level by the states, by the citizens of the states and the representatives, rather than by the court. It's disappointing to see the representatives of the people in Congress having been overruled here, but I take heart in the fact that this is an issue that will hopefully still continue to be worked on at the state level. We see that in things like Roe v. Wade, when the Supreme Court goes in and tries to force a definition for the whole nation and constitutionalize an issue that's not there, it often does have a backlash and just cause further division in our society. So I'm hoping that doesn't happen, but we'll see. I'm hoping that leaving some of these decisions to the states will still allow the people to be the proper sovereigns and not the courts.
And the President of the United States, his official Twitter account has now reacted to this decision by the Supreme Court to go ahead and overturn the Defense of Marriage Act at Barack Obama, writing just a moment ago, today's Doma ruling is an historic step forward for hashtag marriage equality. And he goes on to say hashtag love is love. Jake Topper, the first of two major decisions. We're awaiting a second major decision on the fate of Proposition 8, which bans same-sex marriage in California.
That's right, Wolf. And while we're waiting for the decision in the California ban on same-sex marriage, shorthanded as Proposition 8, Jeffrey Toobin, Jonathan Turley, and I are going over and reading not only the opinion that has struck down the Defense of Marriage Act, but also a very blistering dissent by Justice Scalia, who calls what the court did today, quote, jaw-dropping. He uses the term judicial supremacy. Jeff Toobin, I don't think I've read anything quite this pointed since the Stevens dissent in Bush v. Gore.
You know, this is the culture wars come to 1 Street, across the street over there. I mean, Antonin Scalia believes that the government is perfectly entitled to legislate morality, and lots of people agree with him. Here's a line:
the government, but not the court,
not his colleague, not 5 of his colleagues today. As I have observed before, he writes, Justice Scalia, the Constitution does not forbid the government to enforce traditional moral and sexual norms. And that is a widely held belief. But he was outvoted this time, that gay people cannot have their sexuality demeaned, as Justice Kennedy wrote in the majority opinion. But that fight over the status of gay people and whether the government is allowed to discriminate against gay people, that's the heart of the dispute between the 5 justices in the majority and the 5 in the minority.
All right, I'm going to throw it back to you, Mr. Blitzer, back in the D.C. Bureau.
All right, guys, stand by for a moment, because we now know that there has been a decision in the second gay marriage case involving what's called Proposition 8 in California. That proposition rejected same-sex marriage. The case is called Hollingsworth versus Perry. Let's get some background, because we're going through the paperwork right now. John King, once again, is joining us with a closer look at this second same-sex marriage case that the justices have now considered.
The big question is, do we get a sweeping ruling from the court like we just did in Doma, or is this a much more limited ruling to the state's issues, the specific issues in this California case? Hollingsworth versus Perry, it's worth remembering, California had same-sex marriage, then took it away, meaning the state Supreme Court said same-sex marriages were legal in the state, but then voters took it away when Proposition 8 passed. Proposition 8 passed on a statewide ballot initiative, and it took away the rights of same-sex marriage. It defined marriages between a man and a woman in California. Here's the argument now for the Supreme Court. The argument from the proponents of Prop 8, those who want marriage to be only between a man and a woman, they say it was passed by the voters. Therefore, the state has endorsed Proposition 8. The state should have the right to keep it. And they also argued to the court that that Prop 8 should be legal, and marriage should only be between a man and a woman because, in their view, marriage is about procreation. That was the argument of Prop 8 supporters before the court. The petitioners responding said no, that Proposition 8 violates their equal protection clauses under the Constitution, that a woman and a woman or a man and a man could have every right to get married. And as Gloria was noting earlier, Wolf, as we wait this decision, again, it's a big question. The court could issue a sweeping ruling that essentially says yay or nay on the question of same-sex marriage or states' rights to have same-sex marriage, or there are questions about standing or more limited legal questions, so the court is going to sort this one out. But what do the American people think about this? About 55% of Americans now believe, so you have a majority, but still 44% of Americans say no to the question of whether the government should marriages between gay and lesbian couples be recognized as valid. And some other ones here, if you look at this by age, this is one of the defining things when you look at polling about same-sex relationships, is the generational divide. Younger Americans, nearly 7 in 10 say yes, you should be able to marry who you love, regardless of sex. Older Americans, of course, say no. It's a generational question here. So as we wait for this, obviously the first question is how broad of a ruling do we get from the court? Then the second question is, once you have that ruling, how does it then play out back in California, where Prop 8 is from, and then in so many other states across the country, having this conversation and legal debate.
Stand by, John. A good explanation of what's at stake here in Hollingsworth versus Berry. This is the case involving what we call Proposition 8 in California, which overturned gay marriage, which had earlier been approved by the top justices out in California. Proposition 8 by 52% vote during a referendum rejected that, and now we're going to find out what the 9 justices of the Supreme Court think about this. Lori Borger is here with us. Lori, you've spent a lot of time with the lawyers who were arguing against Proposition 8 before the Supreme Court.
I have, and they were making the argument about the Equal Protection Clause. Ted Olson and David Boies, one Democrat, one Republican, arguing that Prop 8 violates the Equal Protection Clause of the Constitution. They have said to me this is the last great civil rights fight of their generation. So they would like to have a broad ruling, such as the ruling you got on the Defense of Marriage Act. However, just because you got that ruling on the Defense of Marriage Act does not necessarily mean you're going to get it on Proposition 8. And I can tell you, whatever the ruling is on Proposition 8, it's going to be politically interpreted, and you're going to have to look at the details of it to determine how the state of California would react to it.
Whether or not there will be same-sex marriage in California or not. Tom Foreman is taking a closer look as we go through the decision. Read it carefully, precisely. Tom, set the scene for us.
Well, think about this, Wolf, where you just heard this other decision. There are 300 people in the court right now hearing the Prop 8 decision, and this is what they heard from the justices back in March. Listen to what Justice Kennedy, so critical in all this, said. He said Prop 8 took the court into uncharted waters, and he expressed concern at the time about children in California because the state does recognize same-sex marriage. He said if you don't treat those marriages the same, don't you pose an immediate injury to some 40,000 children out in California. Justice Sotomayor jumped in, and she said she was concerned about the fact that the state would be denying a benefit to people on one area where they wouldn't in any other. She said, is there any other rational decision-making that the government can make, denying them a job, not granting them benefits? Justice Scalia, in all of this, as you might expect, challenged an attorney representing the gay rights side with a simple question: when did it become unconstitutional to exclude homosexual couples from marriage? And Justice Alito hit at what many people thought would be the key coming into today, the sheer speed with which all this is moving forward in terms of a movement in our society. He said about the court, you want us to step in on the effects of this institution, which is newer than cell phones or the internet. Why should it not be left for the people? That's what they said back in March, but Wolf, as we can see today, they are stepping in a big way. We'll just have to hear what they say about Prop 8.
We should know momentarily. Tom Foreman, thanks very much. Gloria, once again, is here. John King is here as well. Gloria, you spent a lot of time looking into this Proposition 8 debate, and what we should be getting, if we get a clear answer from these nine justices, is whether or not same-sex couples will legally be allowed to get married in California.
In the state of California. And I spoke with one of those same-sex couples who are the plaintiffs. And let's take a listen to what Chris Perry said to me about the difference between marriage and domestic partnership.
Domestic partnerships have nothing to do with love. They're not about love. They're about health benefits, title, protections in hospitals, perhaps, if you're fortunate enough to have that kind of domestic partnership. In our case now, it results in increased taxation. It is not the same thing. In fact, most people would be surprised to know that Sandy and I have to have 3 different domestic partnership agreements in order to comply with employer requirements. We are domestic partners in the city we live in, the county we live in, and the state we live in. We have 3. None of them, not one of them, can I tell you the date at which it was executed, nor can I tell you for how long we've had them. But I can tell you this, the day I get married, I will remember that day, and I will celebrate that day every year with Sandy.
Let me ask you, not being allowed to marry, how has that impacted you every single day of your life?
It is the most important decision one makes in their adult life. Not being allowed to do so makes me feel like there must be, that society thinks there's something kind of wrong with us. If there weren't something wrong, then why wouldn't we be allowed to get married?
And these 2 women are at the court today, as are the other plaintiffs, and one of their attorneys is there today. Ted Olson happens to be trying a case in Philadelphia today, of all things, Wolf. But they have been working on this case for most of the last 5 years.
A lot of our viewers remember Ted Olson and David Boies from the 2000 critically important case that allowed President George W. Bush to become president of the United States.
And Ted Olson, being a conservative jurist who's tried, I believe, 44 cases before the Supreme Court, is somebody that surprised a lot of people that he was doing this on same-sex marriage. And he brought his old opponent, David Boies, into the case because they believe, of course, that this isn't a political issue. They believe that it's a human issue and it's a constitutional issue of equal protection. We'll have to see.
Let's talk a little bit about the President of the United States because he's obviously put a lot of, he now supports, he used to oppose same-sex marriage. Within the past year or so, he has formally come out in favor of same-sex marriage. And it's become, he even referred to it as an inaugural address. For him, this is sort of a legacy issue.
It's a legacy issue now, and it's a huge evolution since you raised the point. I'm going to take a walk back over, if that's okay, because we can go through the president's evolution on this issue. Well, remember, when the president ran for office, when he was in the state senate in Illinois, and when he was a U.S. senator and first came to Washington, he was opposed to same-sex marriage. And let's take a look and just go through the president's evolution of this, because the president's evolution, in many ways, if you look at public opinion polls, mirrors the country's evolution. And let's go back. This is the president back in October 2004, when he's just into the United States Senate.
What I believe is that marriage is between a man and a woman. But what I also believe is that we have an obligation to make sure that gays and lesbians have the rights of citizenship that afford them visitations to hospitals, that allow them to be to transfer property between partners, to make certain that they're not discriminated upon the job. I think that bundle of rights are absolutely.
As far as why, what in your religious faith calls you to be against gay marriage?
What I believe in my faith is that a man and a woman, when they get married, are performing something before God, and it's not simply the two persons who are meeting.
Now that's the president in 2004, again running for the United States Senate. Here he is as president of the United States 6 years later, in December 2010, saying that, on this issue, he's having second thoughts.
My feelings about this are constantly evolving. I struggle with this. At this point, what I've said is that my baseline is a strong civil union that provides them the protections and the legal rights that married couples have.
Now, the president faced a lot of criticism from his liberal base, including the gay rights community on that point right here. And here's the president in his inaugural address in 2013. I'm going to stop. I'm sorry, Wolf. Let's go back to you for the details here.
All right, let's go to Jake Tapper right now. He's got Jeffrey Toobin and Jonathan Turley. They've now gone through the actual Supreme Court decision, Hollingsworth versus Perry. Go ahead, Jim.
Thanks, Wolf. Well, there has been a sweeping decision earlier today having to do with the Supreme Court striking down the Defense of Marriage Act, saying that if a state recognizes same-sex couples, the federal government cannot refuse them recognition. Now comes the ruling in the California same-sex marriage ban, Proposition 8, and it's an unusual ruling. It's one that brings together an odd coalition of justices, 2 conservatives, 3 liberals. Jeffrey Toobin, what exactly did the court decide here?
You know, I'm not afraid to say, Jake, that this is a puzzling decision. It's a puzzling lineup of justices. Let me just say who's on which side. This decision in the California Proposition 8 case is written by Chief Justice Roberts. It is joined by Justice Scalia, Justice Ginsburg, Justice Breyer, and Justice Kagan. 2 strong conservatives, 3 liberals. The dissenters in the California case are Anthony Kennedy, who wrote the majority opinion in the Doma case, Justice Thomas, Justice Alito, and Justice Sotomayor. So 1 moderate, 2 conservatives, 1 liberal in dissent. That's the lineup. What they hold, the decision is that Hollingsworth, who was defending Proposition 8, had no right to be in court. Remember, this is a case where 2 people who wanted to get married in California sued and the state of California to say that Proposition 8 was unconstitutional. The governor of California, Jerry Brown, the attorney general of California, Kamala Harris, said, we agree with you. We think Proposition 8 is unconstitutional. So there was no one there to defend the law until Hollingsworth, who was one of the original supporters of Proposition 8, but who had no legal status, stepped in to defend the law. What the 5 justices in the majority have said is that he didn't have the right to do that. What that means today for whether same-sex marriages can resume in California, I'm not sure, frankly. Jonathan, do you know?
Well, what it means is that the Ninth Circuit never really did have jurisdiction. So it essentially negates what the Ninth Circuit does, and that, of course, puts all the attention back on the trial court. And presumably, that court did have jurisdiction, and the opinion would still stay valid. But as you know, Jeff, it's very ambiguous. And this is an example how standing, makes for strange coalitions. If you look at these 2 cases, the standing issue was just as severe in the first case, where you had members of Congress defending the law. I represented members challenging the Libyan war, and we were thrown out because the court would not recognize standing, and here they have. So you have these shifting standing grounds that you have. But I think that what you're going to see is there's going to be, as Jeff notes, a lot of attention on that trial court decision and whether it still has legs. Even if the Court of Appeals didn't have jurisdiction, whether they can just go ahead then and say, all right, this stands. Proposition 8 is not good law according to that trial judge, and therefore the gate is open for marriage.
Does that mean that we are a way that, just for people to remind them, Proposition 8 was a law passed by the voters of California in 2008. They overwhelmingly went to vote for the polls, but went to the polls to vote for President Obama in 2008, and they not overwhelmingly, but a majority of them went and voted against same-sex marriage in California. Does that mean that that law stands, or that it was stricken down because it was stricken down by that first court?
That's the question, and I don't think this opinion explicitly answers that question, but there's a political context here, too. California politicians, the leadership of California, the governor, the attorney general, the mayors of San Francisco, the mayors of Los Angeles, they want same-sex marriages to resume. If there is any ambiguity in this opinion, and I think there is, they are going to interpret it as a green light to go forward. So I have to believe there will be more legal proceedings in California based on this, but I think you're going to have the whole political infrastructure of California saying, it's time to go, it's time to let people get married, they've been waiting long enough, they've won all these cases. So I anticipate the political leadership is basically going to say, come and get me, copper, come stop me from doing these marriages, and I don't know if anyone will.
And the key sentence in this decision has to do with precedent. The court says, we've never before upheld the standing of a private party to defend the constitutionality of a state statute when state officials have chosen not to, and we decline to do so for the first time here. They're saying this has to do with precedent. We are not going to let individuals come forward to defend state laws if the state refuses to defend them.
Right. And I think that, Jake, one of the interesting aspects, and we talked about this a little earlier, is what type of effect the sweeping language in the first decision will have on this continuing debate. Kennedy went out there and said, this is about marriage. It doesn't matter who the partners are. When he looked at federal benefits, and he gave very strong equal protection language that was missing in the Lawrence decision, it's now there. And so the interesting question is going to be, as this returns to California and frankly all the states, is how much effect that's going to have on people. Because Kennedy went as close as he could in that opinion to saying there is an equal protection for same-sex couples, but he did not go all the way to make that whole.
Well, and certainly Justice Kennedy's opinion in the Doma case is a invitation to two women who live in Alabama or Mississippi or Texas or any of the 38 states that don't have same-sex marriage to file a federal lawsuit and say, we have a right to get married. The situation now is just like it was before the Supreme Court decided Loving versus Virginia, which was the case in 1967 that said state laws that bar racial intermarriage are unconstitutional. We seem to be moving in that direction to have a federal law, a federal constitutional guarantee of a right to same-sex marriage. Certainly Justice Kennedy invites that kind of challenge. We're not there yet, but you can bet those cases will be filed soon.
What's unusual is we clearly have 5 justices who think that same-sex marriage should be legal. There is a constitutional right to same-sex marriage. They're under the Equal Protection Clause. Is that fair to say?
Well,
or am I saying it too strong?
I think Kennedy comes very close to that. I mean, he still left himself a little bit of room. But Jake, I think the most interesting thing about these opinions is the fact that those people like Scalia who are saying that morality legislation is an appropriate and perfectly valid form of law are in the distinct minority. If you compare this to what happened before Lawrence, where the whole court, well, not the whole court, the majority of the court at once said that you could criminalize homosexual relationships. And
I'm sorry to interrupt. Those are the petitioners right there in the Hollingsworth v. Perry case that we're seeing, along with their attorney David Boies. I don't see Ted Olson there.
Ted Olson is arguing a case in Philadelphia.
Ted Olson's arguing a case in Philadelphia. But those are the same-sex couples who sued the state of California, and it came all the way to the Supreme Court. They seem to be very triumphant, although obviously it was an ambiguous decision, as we've discussed. Gloria Borger, you have interviewed David Boies at length about this case.
Right, and I think the question that we're all asking is whether the California District Judge on Walker's ruling would then stand to a degree, and it was a very broad ruling, which may be why they're cheering. To your political points here, though, these people will say that within a month there will be same-sex marriages in the state of California. I think state officials clearly have to read this opinion very carefully to get a guidepost about what they can and cannot do. But there's Ted Boutros, another lawyer who argued the case along with David Boies, and Ted Olson, as you point out, is arguing another case. In California, there's Chad Griffin, the head of the Human Rights Campaign, who's been on this case from the very beginning, was one of the people who decided to take it up before the court. And let's hear what they have to say.
It's interesting because right now we should know fairly soon, and I'm anxious to get Jeffrey Toobin and Jonathan Turley and others to weigh in. And I guess the practical question so many folks, especially in California, want to know, will same-sex marriage be legal in California within the next few days? Here are those who support same-sex marriage. Let's listen in.
I'm the executive director of the American Foundation for Equal Rights. It's my great privilege to be here this morning with the plaintiffs' legal team and founding board members of the American Foundation for Equal Rights. Speaking first will be David Boies.
This is a great day for America. 10 years ago today, the United States Supreme Court in Lawrence against Texas took the first important step in guaranteeing that all Americans, regardless of sexual orientation, were equal citizens under the law. Today, the United States Supreme Court, in two important decisions, brings us that much closer to true equality. In the decision striking as unconstitutional the so-called Doma or defensive marriage case, the United States Supreme Court held that there was no purpose for depriving gay and lesbian couples of the right to marry the person they love. There was no legitimate justification for that. As Justice Scalia noted, that holding, that principle, guarantees the right of every individual in every state to marriage equality. In the California case, the Supreme Court held that the proponents of Proposition 8 did not have standing. What that means is that in that case, the Supreme Court could not reach the merits. But everything that the Supreme Court said in the defense of marriage opinion, where they did reach the merits, demonstrates that when that case finally does come to the United States Supreme Court on the merits, marriage equality will be the law throughout this land. Our plaintiffs now get to go back to California and together with every other citizen of California, marry the person they love. And the next step is to translate the promise that was in Lawrence and it was reaffirmed today in the Doma case, that every citizen in every state has the right to marry the person that they love. The Supreme Court's decision on standing is important for another reason. When we started out in this case, we said we were going to prove three things. We were going to prove that marriage was a fundamental right, and the other side accepted that. We said, second, we were going to prove that depriving gay and lesbian citizens of the right to marry the person they love seriously harmed them and seriously harmed the children they were raising. And even the opponents agreed with that. And third, we said we were going to prove that allowing everyone to marry the person that they love, regardless of sexual orientation, did not, could not harm anyone. And not only did the proponents on cross-examination have to accept that, but today the United States Supreme Court said as much, because they said the proponents have no concrete injury. They cannot point to anything that harms them, because these two loving couples, and couples like them throughout California, are now going to be able to get married. And so this is a wonderful day for our plaintiffs. It's a wonderful day for everyone around this country, and in California in particular, that wants to be able to marry the person that they love. But it's a wonderful day for America, because we have now taken this country another important step towards guaranteeing the promise that is in our Constitution, in our Declaration of Independence, that all people are created equal, that all people have the inalienable right to life, liberty, and the pursuit of happiness. So this is a great day. We thank the Supreme Court. We thank all of you, and perhaps most importantly, we thank all of the people who have devoted so much to this battle over so many decades. People who did it at a time when it was not as easy as it was for Ted Olson and myself to go into court. The only thing I regret today is that my friend and colleague Ted Olson can't be here.
He has been a leader in this battle for the last 4 years. He is unfortunately today in another court, in another part of the country, arguing another case. But his spirit is here, and he will be with me tonight, and we will celebrate. Because this is a victory, not just for us, not just for the plaintiffs, not even just for the people who have worked for this so many decades, but for all Americans. Thank you.
We'll now have comments from Chris Perry and Sandy Stewart, plaintiffs in the case.